Good morning to all of you. Welcome to Legal Matters by Sai Babu Sunkar. అందరికీ శుభోదయం. Honorable Justice Atul Sridharan and Dinesh Kumar Paliwal, while dealing with the case of Anupama Alice Minj, Anupama Alice A-L-I-C-E Minj versus National Law Institute, University Bhopal, in writ petition number 970 by 2025, yesterday, that is on 2nd July 2025, held that physical classrooms are always better than the so-called virtual classes. In other words, virtual classes are a poor substitute to physical classes. So definitely, the classroom lectures are more important. The physical interaction is more important. So therefore, simply saying that I have attended the course online is not sufficient. It is not substitute for physical classes. Why this has come up in the case of this Anupama Minj? Because she was not allowed to appear for the exams, for the semester exams, due to which she lost 1 year. Actually, she says that she is suffering from spinal medical condition. మనకి నడుము నొప్పి అంటాం కదా, స్పైన్, L1, L2, L3, L4 అలాగే ఇంకేదో కూడా ఉంటాయి. So she says that she is suffering from spinal medical condition. Therefore, there was a shortfall in her attendance. She could not attend the course regularly. There was some shortage in attendance. Actually, taking into consideration of her medical condition, the university reduced the percentage of attendance to 60. But the attendance by her, that means the classes she attended were only 54.8%. Therefore, they could not do anything except to stop her for writing the semester examinations, due to which she lost 1 year. Actually, you know, as per the BCI legal education rules, particularly rule number 12 and rule number 17, they say that you should have 75% attendance. If not, there should be some sufficient reason for condonation. All these things are there. But university reduced it to 60%, but it is also not enough for her. Therefore, university did not allow her for the examination. As such, she came to the High Court. Right. Of course, the relaxation should be provided basing on the circumstances. Should not be one size fits all. మేము ఒకటి చెప్పాం అందరికీ ఇదే అంటే కుదరదని కూడా ఆవిడ she has argued, her lawyer argued in the court. But very important point, High Court took the firm stand that legal education demands classroom engagement. Human interaction, classroom environment, they are all essential. Of course, in exceptional cases like Corona, we allowed the live classes. Corona, in the view of High Court, we can say definitely it is an act of God. So, virtual classes, they are exception than to the physical classes. But you can't take that you have attended the virtual classes. Idi main. Andukane, please remember, I see, I forget. I read, I forget. I study, I could recapitulate to some extent. But if I hear through some other source, If I interact the same with other persons, definitely I remember the same. కాబట్టి పంతులు గారు చెప్పింది విని ఆయనతో ఇంటరాక్ట్ అయ్యి ఏదైనా క్వశ్చన్లు వేసి మాట్లాడితే, సరే మాట్లాడకపోయినా, మీరు ఎటు తెలుసు చాలామంది మాట్లాడరు నాకు తెలుసు, మాట్లాడకపోయినా ద ఇంటరాక్షన్ విల్ బి డెఫినెట్లీ. రెండవది క్లాస్ రూమ్ ఎన్విరాన్మెంట్. కరోనా టైంలో చూసాం పిల్లలు, సో రకరకాల భంగిమల్లో మేము చూసాం. ఇప్పుడు నిన్న కూడా ఒక వీడియో చేసాం, జడ్జి గారు ఎవరో లాయర్ గారు బీరు తాగుతూ కోర్టులో అటెండ్ అయ్యాడు. ఈ భంగిమలను చూడాలి. అదే క్లాస్ రూమ్ అనుకోండి, ఎన్విరాన్మెంట్ ద క్లాస్ రూమ్, యూ హ్యావ్ టు కమ్ టు ద క్లాస్, యూ హ్యావ్ టు కమ్ ఇన్ ప్రాపర్ డ్రెస్, అట్లీస్ట్ ప్రాపర్ అటైర్, యూ హ్యావ్ టు బి అటెంటివ్. అంతేగాని ఇంట్లో పనులు చేసుకుంటా, వంట చేసుకుంటా, లేదా కాఫీ తాగుతా చేయడానికి లేదు. క్లాస్ రూమ్ ఎన్విరాన్మెంట్ ఈజ్ డిఫరెంట్. డిసిప్లిన్ కమ్స్ ఆటోమేటికల్లీ. రియాక్షన్ విత్ అదర్స్, ఎందుకంటే లాయర్లో డెఫినెట్లీ ఎక్స్చేంజ్ ఆఫ్ ఇంటెలిజెన్స్ ఈజ్ వెరీ వెరీ ఇంపార్టెంట్. ఎక్స్చేంజ్ ఆఫ్ లీగల్ నాలెడ్జ్ ఎలా వస్తుంది? నలుగురు మాట్లాడినప్పుడు ఒక్కొక్కటి మాట్లాడుతున్నప్పుడు ఆటోమేటిక్గా తెలుస్తుంది. దేర్ఫోర్ ఫిజికల్ క్లాసెస్ ఆర్ ఆల్వేస్ బెటర్. సో BCI, Bar Council of India says, of course, a committee has been formed to look into the issue regarding the medical conditions. Actually, Bar Council says the university lacked the authority to reduce the percentage of attendance up to 60% also. Actually, BCA says the attendance, minimum attendance 75 to 65. 65% is the cap. University can't go beyond that. Okay. But the student says these rules are like one size fits all, because you have to take into consideration the individual circumstances. It may lead so many things అని చెప్పి అన్నారు. 1 year, precious 1 year is lost అన్నప్పుడు the certain people, they are tending to commit suicide అని కూడా లాయర్ గారు he has taken to the notice of the honorable court. Then the reaction of the judge: when we were students, we never heard of any suicide, but basing on the allegation or basing on the premise that certain students commit suicide, you cannot lower the standards of the legal education. If a person commits suicide, there are 101 reasons. You get 1 more year to improve yourself. You think in a positive way. You get 1 more year to improve yourself. No relaxation. Classroom lectures are central to academic excellence, academic learning. ఎంత చెప్పినా కోర్టు ఒప్పుకోవాలి. కాబట్టి మిత్రులారా, my dear students who don't come to the classes, please remember that the court is always insisting, the High Court is saying that classroom lectures are better than the so-called video lectures or other things. Okay? So, hear this, at least make your attendance అప్పుడప్పుడు కనపడుతూ ఉండండి. So, I am stopping here. Thank you very much.